Okay, great. Go ahead and take a seat if you'd like. You're Ms. Jackson and you're Mr. Eliezer Jackson?
Yes.
Okay, very good. I believe there was a notice of disqualification filed, and I'll just pull that up just to confirm that. Okay, it looks like that was filed on 23rd of February, so I won't be able to hear the matter today since that's been filed. So we'll take a look at some other dates for that presentation of the order. So we'll set it over to June 21st. Let me just confirm that's the correct date. June 21st it is at 8:45, and we'll see everybody then.
Okay,
Thank you.
Thank you.
Gilmore representing Timothy Fraggle.
Yes, Your Honor.
Okay, great. And then Marcelia Fraggle, are you on the line? Okay, not hearing a response. We're on today for a presentation with Judge Hahn being absent. Ms. Gilmore, do you have a preference of, well, I'm assuming you submitted orders, correct?
I did, and I did speak with Ms. Fragel about the setup because I am aware she has an objection. I am fine with either the 2nd or the 9th. I indicated to her that I thought it would be in July, but I didn't specify, I can't speak, if it was the 2nd or the 9th.
Okay, so did I hear either the 2nd or the 9th would work okay?
Yes.
Okay, let's set it for July 2nd at 9 o'clock. Mr. Baldwin?
That works, thank you.
Present, and also Ms. Holder. See Ms. Holder's there.
I'm here also, Your Honor.
Oh, there you are, Mr. Baldwin. Great. It looks like there's a notice of disqualification filed just recently, so we can look at moving that matter to either the 2nd or the 9th of July.
Is there an earlier date possible, Your Honor? My client's big concern is it's Father's Day this weekend, and he hasn't had any visits. I know you can't hear the case. I don't know if there's any other dockets that are available this week, but it's incumbent on me to at least make the request for my client if we're not able to resolve something in the interim.
Yeah, I can take a look. My understanding on the dockets from here until July 2nd is that they're over capacity. So let me just take a quick look. Okay. Madam Clerk indicated that one possibility would be tomorrow on the self-represented family law docket with Commissioner Warning, and that would be tomorrow at 9.
I can be available if Ms. Holder is, Your Honor. I have a settlement conference, but I can put that on hold to address the matter if she's available.
I'm available.
Okay, great. So we'll set it over to tomorrow, the 12th of June at 9 o'clock in the morning. I'll forward the working copies to Commissioner Warning.
Thank you, Judge.
We should have Mr. Anacostia. He's present.
Right, thanks, Mr. Baldwin.
Representing
Thanks,
Mr. Cox, and then
Thank you.
Rebecca Masudi. Are you on the line? Okay.
Yes, I'm here.
Okay, very good. Welcome to you. All right.
So, Your Honor, in this matter, there's been a resolution, and the parties and the guardian ad litem have signed off on a modification and a parenting plan granting custody to Ms. Masudi, that's over to the court. This was being circulated yesterday, and I didn't have time to get it to the court yesterday, so it was delivered this morning. There are agreed orders giving custody to the mother, and this matter should be resolved.
Okay, Ms. Masudi, are you in agreement with those statements?
Yes, Your Honor, I am.
Okay, very good. So it sounds like, Mr. Agnostic, you said that they should be on the way over, if not already here at the courthouse.
Correct.
Okay, great. Well, once those are, we have those, we'll make sure that those are signed off on. I'll go check the box once we're done this morning and make sure those are signed.
Perfect.
Okay. Any questions, Ms. Ford?
Actually, I do, just because I have an attorney in the guardian ad litem case, and she was wanting to know if they were already filed. So what do I tell my attorney?
I have been in communication with Ms. Masudi's attorney in the guardianship case. There's a guardianship case. And it's my understanding there's a third party guardian that has custody, basically placement of the child at this time, that matter is going to be dismissed in favor of Ms. Masudi getting custody under this action. But that's just in process, so.
Okay. Because I believe for the guardian case, it's next Tuesday on the 18th.
Right.
Okay.
All right. All right. Very good. Any other questions?
No, Your Honor.
All right. Very good. We'll make sure we get those signed today, and that'll conclude that for today. Thank you.
All right,
There
thank
we
you. Have a
Ms.
good day.
McLean present representing Mr. Daly. And Ms. Shariah Nelson, are you on the line today?
Yes, Your Honor, I am.
Okay, great, welcome. And we have, is Ms. Schaefer on the line today? Jennifer Schaefer?
Yes, I'm here, Your Honor.
Okay, very good, great. All right, let me just pull up my notes just one moment. All right, this is Mr. Daly's motion related to his motion to prevent relocation. And
That's correct, Your Honor.
so I've read all the pleadings related to that have been submitted. So I'll hear from Ms. McLean first and then from, sorry, Ms. Nelson thereafter.
And the only comment that I would have as it relates to testimony or argument from Ms. Nielsen is that I have received absolutely no responsive documentation from Ms. Nielsen. Ms. Nielsen was personally served on May 20th. Obviously, more than 20 days have passed since she was served, and the docket notice clearly identifies that her responses were due on May 28th. Clearly, as you can see, she's had no difficulties filing responsive documentation in this case. So I'm concerned about her potentially bringing up issues that are not included in her notice of intended relocation that my client hasn't had an opportunity to respond to. We are asking the court to restrain the relocation of 2-year-old Paisley. It is accurate that she emailed that notice of relocation directly to him. Apparently, there was some colloquy in open court about that. Technically, I think even as a party, she would have an obligation to have a third party do that in order to provide for appropriate service. My client had continued to comply with third party service to make sure that there was an independent witness. So I would just raise that technicality. My client provides as attachment A to his declaration the documentation that he had prepared as far as his objection. If you review through those attachments, you'll note that most of those documents were dated, I think it was April 7th. He actually had an appointment with me. That was our very first initial consultation on April 17th. I reviewed through that documentation with him. I provided him with additional documents, which included the notice for hearing, the declaration, and a proposed temporary order. And when you look at all of those documents, you'll note that those were dated for April 17th, because that was consistent with when he met with me and we went through those. He had also prepared and I had reviewed his contempt documentation, and you'll note that his contempt motion was filed on April 18th, but when he attempted to file his objection to the relocation, the clerk's office denied his filing and said that it was not a legitimate filing. There was no basis for him to file that. So he's been substantially prejudiced after having met with me and gone through the documentation that he needed to file. I don't know if the clerk's office didn't see the relocation that had been filed by Ms. Nielsen back on February 27th. I guess procedurally, my concern is as a practitioner, obviously, if I'm having documentation that's rejected, there should be some notice that's provided so that an individual, particularly a pro se, has the ability to come back to court and say, look, I attempted this. This is what I attempted. And this is what I received from the clerk's office denying my filing. But he's here before the court because he attempted to timely file and that was rejected. So he has been substantially prejudiced as far as timeframes and information goes. We are asking the court to restrain the relocation. If you go back and look at Ms. Nielsen's notice of intent to relocate, she provides her reasons at paragraph 3 to have more stability and to better my daughter and I's life. I have a job lined up and a place to stay. There has been absolutely no information or documentation relative to a job that she has lined up or what, and she identifies an address on where she wants to stay. The cost of living in Caldwell, Idaho is at least double, if not more, on housing alone. And we provided that information attached to Mr. Daly's declaration as it relates to the address that she's identified. And the cost for rent for that location alone is $2,050 a month. So again, it's concerning as it relates to the good faith basis for this, again, because we have no idea as far as whatever job she anticipates she has or has been offered.
Can I ask you a question, Ms. McLean?
Sure.
In Ms. Schaefer's report, there was discussion of Idaho and there's also discussion of Renton. Did you receive any notice regarding potential move to Renton?
Did receive no notice involving Renton, and I would also note that Ms. Schaefer's discussion about relocation exceeds the scope of your order as far as her appointment. If you go back to her report, even on page 2, or on page 1, it identifies that her report was to investigate issues related to making a parenting plan for this child, abandonment or neglect, domestic violence, substance abuse, and any other issues discovered that could affect the safety of the child. She was not charged with investigating relocation. There's obviously, 9 factors that need to be involved. I don't see any discussion about those factors. My client was not asked about those factors. So the suggestion about school, obviously not identified in the notice of intent to relocate. Renton, not included in the notice of intent to relocate. And there needs to be a full investigation relative to relocation and the 9 factors that are involved. My client needs to have an opportunity to weigh in and to produce his evidence relative to those issues. So the one line about being able to relocate to Renton, I don't even know at this juncture what schooling she's supposedly taking that's 2 days a week, what this intended program is that she wants to get into. There's a vet tech program down at Portland Community College. That's 45 minutes, an hour away compared to going up to Renton. And again, the cost of living, when she could maintain her cost, or she could maintain her home here and commute back and forth to school. There's also online availability for vet tech programs. So those are issues that have not been ferreted out. My client, again, was not asked one question by Ms. Schaefer about relocation because that wasn't part of her duties as far as the guardian ad litem appointment order for her. When you look at where we're at as far as this current case, obviously my client has visitation with the child. His position is that he has a bonded relationship with the child and that was unilaterally interrupted by Ms. Nielsen. Interestingly, 4 days after she filed her notice of intent to relocate is when she started to deny my client's visitation for a protracted period of time in violation of the court order, and she was subsequently found in contempt for that. Our position is that we do not believe that there is a likelihood that the relocation will be approved once there is an investigation and both parties have had an opportunity to weigh in on all of the factors of relocation. My client has his bonded relationship. Historically, my client's family has had, extended family who lives locally has had a bonded relationship with the child. The paternal grandmother provided work-related daycare for these parents when they were together here locally. There clearly is no agreement between the party. This is a young child. She's 2 years old. It's crucial time, and the statute talks about having consistent contact and maintaining relationships with both parents. That's in the best interest of the child. That's the overriding concern here. Our position is that it would be more detrimental to move the child from bonded local relationships to an unknown location that is much more expensive with no extended family in either of those areas. We're currently operating under a temporary order, so there have been no 191 findings in this case. There has been no proof of any efforts by mom to obtain employment locally, to provide other educational opportunities locally that would again place a priority on maintaining this child's relationship with her father. My client is full-time employed with an employer where he's been for the last 8 years. He's stable in his housing, and he wants to have a bonded and maintain his bonded relationship with the child. So we're asking that the court restrain the relocation, and we've also asked that the court consider an award of attorney's fees.
Thank you, Ms. McLean. Ms. Nelson?
Yes, I do have family that live in Idaho. My sister, who is a year younger than me.
I guess again,
I'm speaking. I'm sorry, but I am
So
speaking.
Ms. Nelson, sometimes there's objections made when another party's making an argument, and so when objections made, I need to hear what the objection is and rule on that. So just pardon me while I hear that objection. Ms. McLean.
So Again, I'm objecting to Ms. Nielsen providing input to this hearing when she has an obligation to provide written declarations to the court, so that this is not supposed to be by surprise. And again, she's historically filed documentation. She knows how to do that, and the docket notice was clear. So I would object to the court considering any verbal input from her in regards to this motion that has been properly filed and served.
Let me touch base with you, Ms. Nielsen. Ms. Nielsen, did you file any declarations or any information supportive of your different positions, the things you're talking about today?
I'm in the process of trying to get my sister to fill out a declaration and send it to me. She works a full-time job, and my brother-in-law is a truck driver in Idaho. So they have a full schedule. I have asked them to fill out a declaration and send it to me. So I am in the process of getting that. My brother-in-law is the one who is helping me since I'm not in Idaho. He also has spoken to a couple jobs out there, and I am in the process of getting declarations from those as well.
Okay. So those are in process as far as any declarations that you yourself have submitted.
When I filed back in February, I was unsure that I had to submit those evidence. Otherwise, I would have had gotten those a lot sooner. The schooling program that I'm wanting to do isn't the first time that I have been in the process of trying to get done. I'm wanting to be a veterinarian, and it is not the first time that I have been trying to go to school for it. Now that my daughter is older and is able to be in Head Start, there are quite a few different Head Starts near where I live and near the job opportunities that I have in Idaho. There's also one not far from.
Again, I'm objecting because it's exceeding the scope of the court's question.
Yeah, and then any other declarations or from yourself or from others related to kind of a factual basis that I could read and know about, and then Mr. Daly could read and know about?
I don't have them at the moment, but I can get them to the courts.
Okay. Okay. All right. So I think I'm going to sustain the objection. And the reason I'm doing that, Ms. Nielsen, is that the way this process works is that it's really document driven, it's paper driven, where a person will write out their reasons, their rationale, their support for their particular position. That allows me to read and digest it, and allows the other party to read and digest and then respond to that. And then you would have an opportunity to reply to their response to find any shortcomings or things that they overlooked or placed undue emphasis. So I don't have any real documentation from you that lays out your position. I know that you spoke with Ms. Schaefer and you provided her some information, and I reviewed that report. But at this point, there's just the rules just aren't there. There's not a factual basis that's been put in print on paper and shared with the court. So I'll give you 3 minutes to share your view, and then we'll hear from Ms. Schaefer. So go ahead and tell me your 3 minutes of your rationale, and I'll just leave it at that.
So basically my thought process on everything and where I stand. Is that what you're?
Sure. You're just basically your motivations and reasons for wanting to move.
In Caldwell, Idaho, the veterinarian program that they have specifically that I'm interested in going into is a large animal vet program. It is from what I understand, a 4-year program. They have that specific one due to being I want to say a country where there's more farming properties out there, more large animal opportunities. Like I said, it is not the first time that I have tried to go to school. When I first attempted to go to school was in 2020. Before I came back from Texas, I was trying to go to Texas A&M to become a large animal vet. I had moved down there and lived with my cousin for a few months, and that was also when COVID was going on, so I was unable to get into the college. I am a hands-on learner. I don't do good at doing things online and not being in the room learning from a full-on professor or teacher. Doing my research, being a large animal vet, does have its benefits. It's got good dental benefits, good insurance. If my daughter has to have surgery, not saying she does, but if at any point in time has to have surgery on some sort of body part, I'd be able to afford it. So that's why I was looking into Caldwell University out there. My sister, the house that is in Roy's declaration, she is actually mortgaging that house. They pay $1,500 a month. The job or jobs that I have lined up out there, one is at a feed store, and the other one is actually with his friend's wife at a veterinary clinic. So I'd be able to work those jobs when I am not at school and while Paisley would be in Head Start. As of here, Renton is another college that I was looking into going as a second option. That is why that one is not listed, because my main focus was in Caldwell. And I had talked to Ms. Schaefer about Renton as a second option because it is 2 hours away. It is actually one of the cheapest places to live here in Washington. I have done my research on that as well. Now I have a cousin who actually lives in Seattle. He is a full-time worker. I can also get in contact with him and see about him putting in a declaration as well. As far as living in Renton, that won't be a problem with visitations, as I can drive down here from Renton and be a lot closer. And he can still have his week visits and his weekend visits with Paisley if they are still granted. That for Renton, that was my second option. Hence, like I said, why I didn't put it in my declarations. Caldwell was my main source of relocation as far as the large animal veterinary clinic goes.
Thank you, Ms. Nelson.
Mhm.
Turn the time to Ms. Schaefer if you have any comments, Ms. Schaefer.
Yes, I do. I did speak to Mr. Daly about all of this, and his concern was that she was making the move more to get away from him and to separate the father-daughter relationship. As I stated in my report, I do have concerns with the consideration of Idaho. The 7-hour drive one way for the child is not in the best interest of the child. Mom did state that she had other options to look at different schools, and she is also applying for scholarships, I believe, through TANF. And so that's why we were considering that she would need to have some sort of answer by the court so that she could either accept those scholarships and put them into place for further schooling. I felt the child's age, even though she is 2 and would need those close contacts with both parents, it would also not interrupt any schooling for the child per se. If we waited 3 or 4 or 5 years for her to be able to pursue this college education in a more further away location, then we would be uprooting a child who's already started a schooling age and already started an education program. Whereas I felt like Ms. Nielsen might have the opportunity to finish the program before having to disrupt the child's education. So I did put weight into that as well.
All right. Thank you, Ms. Schaefer. Ms. McLean?
Of course, much of what Ms. Schaefer just testified about is not included in her report. I don't see anything in her report, and in my discussion with my client, the factors that are outlined in the statute were not discussed. Again, that's not something that this court tasked her with. Otherwise, we would have provided additional information to her relative to those issues. The cost of living, at least from what I can get online for Renton, is 23% higher than the national average compared to Kelso, which is lower than the national average. There are online programs for this veterinarian associate's degree that she's talking about. There are, again, it's my understanding that there's one available at Portland Community College. There are a lot of moving parts, and clearly my client is entitled to have an opportunity to respond to all of the information clearly that was not included in her notice of intent to relocate. I have no information relative to the schooling that she's currently doing, how far she is in that schooling, what her grades have been. I have no financial aid applications. If she moves out of the state, that's going to disrupt her. I understood that she's receiving TANF as well as state medical for the child, so that would be disrupted. There's just too many parts, and she's, again, come here empty-handed without providing information for us to be able to make determination. So I think the fallback is that we maintain the status quo, maintain the relationship and the bond with the father, and allow this to be fully investigated by a guardian ad litem.
All right, thank you. All right, so we start off any request to relocate with a presumption to the primary custodial parent. The presumption is that the move is allowed. So Ms. Nilsson, under this temporary plan, is technically the primary custodial parent, with Mr. Daly having visitation on the weekends. So, the thing that really strikes me about this case is that there's a lack of information, a lack of hearing from Ms. Nilsson's viewpoint as far as I heard her plan today, and I also read about her plan a little bit from Ms. Schaefer's report. But there's lots of gaps, there's lots of holes. There's 9 factors that were mentioned earlier that need to be reviewed and considered by the court, such as the child's relationship with parents, siblings, other important people, agreements between the parties regarding children, disruption of the child's contact with the mother versus disrupting the contact with the father, if there's any limitations under the parenting plan, her mother's reasons for the move, if they're good faith or bad faith efforts or reasons, and the father's reasons for objecting to the move, whether that's good faith or bad faith, the impact on the child, allowing or preventing the relocation, the quality of life, resources, and opportunities in the current location, in any proposed location, other arrangements to foster and continue a relationship with the child if the move was to be allowed, and alternatives to Idaho, whether Mr. Daly could move to Idaho, and then also financial impact of moving or not moving. I don't have a lot of information related to those 9 factors. I have information from Mr. Daly that shares his point of view. I have even less information regarding Renton. That was in no pleading that I saw from Ms. Nilsson, and there's lots of information related to that's just not there. So I think the presumption has been overcome, and I'll sustain the prevention of the relocation at this point. So certainly there's procedurally there are some concerns related to the pleadings, maybe on both sides, but at this point there's just not enough information for me to allow that. So I think the motion is well taken, and the relocation is prevented at this point.
Okay. I have a question, Your Honor. When I get all of the information to back up my claim, can we come back to the relocation hearing?
Yes.
Okay.
You'd have to basically start over again, providing notice, and then following the procedure and providing documentary proof for your declarations and the like.
Okay.
All right. So
Sorry.
Go ahead, Ms. McLean.
Is the court going to reserve fees?
Oh, I didn't quite hear everything you said.
I'm sorry. Is the court going to reserve fees?
As far as attorney fees, at this point, I'm going to deny attorney fees. If there's another showing of lack of follow through and declarations, then that certainly would be a strong reason for imposing fees. But at this point, I'll deny any additional fees.
I have provided the court with a temporary order about moving, as well as a temporary parenting plan.
They have that. And Ms. Nilsson, did you receive a copy of that order, the temporary order about moving with children, the relocation?
I believe so. Let me see here. There was a lot going on in the packet that I received. It just kind of seemed all over the place. Let me see here.
She would have received a proposed orders packet that has the temporary order restraining the relocation and a proposed temporary parenting.
Okay, it looks like I did get the new parenting plan that he had filed.
I'm specifically looking at the relocation orders. It's a temporary order about moving with children, parentheses, relocation.
Mm-hmm.
So what I want to know is, since that's a proposed order based on today's ruling, do you have any objections or concerns with that order?
In the parenting plan, he's asking for joint custody. I'm still
not talking about parenting plan. I specifically am looking at this document. If you can see that on the Zoom.
It's hard to read it. Temporary
While she's
order.
looking for that, the court will need to make a change at paragraph 5I, as that related to the fees.
On that 5I, I'm simply striking the phrase reserved for further ruling. I struck that and wrote denied.
All right.
Ms. Nelson, did you locate that order?
I'm still looking at it. I found it.
Okay. So the paragraph 1 says the court considered a motion for temporary order preventing move with children. And then it talks about the court finds that the child has not moved yet, talks about the circumstances that don't justify allowing the move before a final decision. And then it goes down to specific findings. And if you look under 5I, that's where I mentioned that I struck the wording reserved for further ruling and wrote in the word denied. And other than that, I don't see any need to change any of the other findings at this point. And if you have any strong concerns or objections with any of that language, please let me know.
Okay. I would like to say, in 5A, as far as from my understanding, Paisley has not seen his side of the family in quite some time. So I don't understand how she would have a bonded relationship with his side of the family. With him, yes, I would like there to be a bond, but when we
we're gonna
together,
focus specifically on the order. If you have any specific objection to any language in this proposed order that we're reviewing, that's kind of the focus of our attention right now. So that's what I'm looking for feedback from you if you have any specific concerns with the language in this proposed order.
I mean, I would like to be able to move and do the proper schooling, and have a better future for Paisley and I will get those documentary filings to you, and if we can come back to this hearing when those are filed, that would be great.
Okay, so I've gone ahead and I'm going to sign off on the temporary order about moving with children with relocation. So there needs to be a trial on the issue, and so there'll be, if you're interested in that, you'll need to put those wills in motion. You can check on washingtonlawhelp.org for additional information on how to make that happen. But otherwise, I've signed off on that temporary order preventing the relocation at this point.
Your Honor, paragraph 6 has you adopting the temporary parenting plan.
Yeah, I'm not prepared to rule on the temporary parenting plan.
So are you going to cross that off and just indicate reserved?
Yeah, I will. Let's just say the court reserves ruling
on a temporary parenting plan until trial, or on a temporary parenting plan?
Yeah, on a temporary parenting plan, and I'll strike until the trial.
Okay, thank you very much. I'll provide conform copies to Ms. Nielsen and Ms. Schaefer once they're available, and Ms. Looney once they're available on Zoom. Or I'm sorry, on Odyssey.
Okay.
Thank you.
number. All right, that'll conclude the hearing today. Thank you. Powers representing Ms. Wolski, I believe. Ms. Powers, I see her. There she is. And Mr. Foley is representing Mr. Torres. Mr. Foley, can you hear me okay?
Yes, good morning, Your Honor.
Good morning. Ms. Height is here as the guardian ad litem.
Good morning, Your Honor.
Good morning. Ms. Looney is present, and I'm not sure if you're directly involved with this, but I think she's signed on, so you're welcome to chime in if need be. So we are here on a review of the case in large measure. There's an interim guardian ad litem report that was filed by Ms. Height in mid-April, which is on for today for a review. So I've reviewed that and the pleadings in the case. So I'll hear maybe first from Ms. Height. We'll hear from you, and then we'll hear from the parties respectively in just in the petitioner respondent order. So Ms. Height first, and then Mr. Torres and Ms. Wolski.
Thank you, Your Honor. As you can see, this report was filed some time ago, and I have an expectation of filing a final report at some future date. I do have a couple of newer pieces of information, nothing that is startling or very different from what appears in my report, but I think it would be helpful for Your Honor to hear that I had a pretty lengthy conversation with the CPS worker in this case, Ms. Naomi Frein, and we discussed the history of it, and some details will be forthcoming in a further report, but the gist of it is that her concerns regarding this case were similar to mine. Her statement was that Mr. Torres is deficient, in her opinion, in decision-making regarding safety of the children, and she was terming that maltreatment rather than abuse, because during an incident in which there was some dangerous driving, no injuries occurred to the children at that time. She believes that Mr. Torres should have a third party present during all visitation, but she does not necessarily believe that professional supervision is needed. She agrees that mental health evaluations or some kind of counseling is appropriate for both parties. One concern that she had that I believe is being addressed through counseling at this time with Ms. Wolski is her statement was that she was concerned that it took such a long time for Ms. Wolski to understand that when she is in danger and duress, so are her kids, and that removing them should have been more of a priority earlier on. That was concerning. And then her final concern was regarding the co-sleeping. She feels like there should be no overnights, which is in agreement with my findings as well. She feels there should be no overnights at this time because of concerns of co-sleeping. She feels like there's no assurance that co-sleeping is not occurring. So those really just kind of underscore things that you will find in my report. In addition, I've had multiple conversations, email exchanges with both parties, phone calls since the filing of my report, and there have been some ongoing concerns from Mr. Torres concerning safety of Mason outside of his home. He has indicated that there's been some bruising. He sent several pictures to me. As you might know, picture quality is typically not real great between a camera and a screen. There were several pictures where I couldn't actually see any bruising. The one or two that I did see appeared to be, and I don't mean to minimize bruising of a child, but there was a couple of penny-sized bruises on her knee that looked very typical of a toddler's bumps and bruises that occur. And again, I don't want to minimize that, but it was not alarming in any way. And I didn't see anything that indicated, nor did the CPS worker. Also of interest is that Ms. Wolski indicated to me fairly recently that the medication that she has been on for anxiety has recently been changed, and it has helped her, especially with situational anxiety that is more controlled, and she's able to function in a more stable way. So all that being said, Your Honor, I stand on my report. I know it's dated a little bit now. I would also like to have the opportunity of having a UA for Mr. Wolski at some time down the road. I know that he had a hair test. He did it at his own time and choosing, which I appreciate that he had it done, but there has been indication of heavy daily alcohol use. And I think by choosing the date that he went, it does impact the validity of that particular part of the score. So I don't know if that will come up in my future investigation, but I would like to be able to have a 2-hour window to have him get a UA if necessary. I don't want to do a whole another hair test. That's pretty expensive, but I think that would be appropriate. So not having a final date for my report, I don't know how long this is going to go out. But at this point, with that being said, I stand on the report that I filed.
Thank you, Ms. Height. All right, can I hear please from Mr. Foley?
Thank you, Your Honor. I guess maybe I'll address this, the CPS comments. I'm not aware of those. We have not been contacted by CPS. The only point I would want to raise with regard to that, the guardian ad litem's report was done the middle of April, and Ms. Wolski brought a contempt motion for, I believe it was May 21st, or that's when the subsequent order was signed, and Judge Hahn did not feel that there was a basis to restrict Mr. Torres from transporting the child. As a matter of fact, it's stated clearly in the order that he is not restricted as long as he has valid license and proof of insurance, which he does. So,
Mr. Foley, was that hearing that Judge Hahn heard, was the driving issue, was that squarely in focus? Was that an issue that was raised during that hearing?
yes, Your Honor. My understanding was Ms. Wolski was asking that he not be allowed to transport the child because of his driving history.
Thank you.
And I may be wrong on that. I don't, Ms. Powers, I don't want to misspeak, but I believe that was before the court.
Thank you.
Okay. And then as far as the guardian ad litem report, you know, I guess to use a phrase that the court used earlier this morning, there is a lack of information with regard to this report. When I read through the report, and I've been through it a number of times, I counted through, I think, the first 10 pages. And there was no mention in the report how the child has been maltreated, how the child is in any kind of a danger. The focus of that report and those first 10 pages centered on this, and I guess for lack of a better word, bizarre sex life that these two folks had. And I think Ms. Wolski has done a masterful job of tainting people's opinion of Mr. Torres by emphasizing this. It should be noted that in the prior protection orders that Ms. Wolski attempted to get, she was granted protection order for her using those same arguments that are before the court today, the same arguments that were before the court last time we were in front of Judge Hahn. And in none of those prior orders was there ever any protection order entered for the child. And the reason for that is, at least in my opinion, is there is no nexus that's been established by the guardian ad litem, by opposing counsel, between the parties' sex life and Mr. Torres' ability to care for the child. And if you do go through the guardian ad litem report, you will not see a connection between those two things. And basically what they're saying is we want to take away visitation between this child and her father because they have this, you know, bizarre sex life. And that's really not a basis. It certainly wasn't a basis for a protection order. So I would ask the court to keep that in mind. The second point is, it was interesting. The report was issued in April, and there was communication between Mr. Torres and Ms. Wolski about possibly adopting some of the provisions of the report. And Ms. Wolski basically said, you know, we're going to stick with the current parenting plan. As far as any exigent circumstances, there were none present that warranted, you know, a fast return trip to the court. So I think that's of interest, because Ms. Wolski and Mr. Torres obviously lived together for a considerable period of time. And I think, you know, her lack of response to this is really due to the fact that she knows there is no harm to this child, even though they did have this strange arrangement regarding their sex life. The report also fails to look into Ms. Wolski's I guess her pattern of removing fathers from their children's lives. She has two prior fathers of children that have no contact with those children. As a matter of fact, One of those children, for whatever reason, we haven't been able to determine why, does not even live with Miss Wolski. And I don't know if it's related to her PTSD, whatever her condition is. But the fact of the matter is that child lives, I think, with her mother. And I would point out to the court that Miss Wolski's PTSD, despite the mention made in the GAL report, pre-existed Mr. Torres. Mr. Torres is not the one who is responsible for her PTSD. So our position is, and I think the guardian ad litem mentions it, that there should be no overnights until the reports are complete. Well, my position is there should be no change in the parenting plan until all of the reports are complete. My client has a roommate, Carly Partain, who was interviewed by the guardian ad litem. She has a 3-year-old daughter from another marriage. They're roommates. They're not involved romantically. And I think one of the things that my client talked to Miss Wolski about was that, because there was a bathing, I think, restriction in the GAL recommendation. And he said, that's fine. Miss Partain will overtake or will assume those responsibilities. So that's one piece that was picked up. But it's interesting to note, Miss Partain certainly had the opportunity to relay to the guardian ad litem, I've got real concerns about Mr. Torres. I'm here. I live with him. I see him every day. I see him interact with his daughter. I see him interact with my daughter. And there was no negative comments made by Miss Partain regarding Mr. Torres' ability to care for his child. Mr. Torres also agreed to the no co-sleeping. And I know that was one of the concerns that was mentioned by the guardian ad litem and eventually by this CPS worker. So that issue has been dealt with. So our position is, until there's more information establishing what the actual nexus is between this behavior that the parents engaged in and how that negatively impacts the child, there should be no change in the plan. I've instructed my client to I believe he's gone through the SUD test. I think it's appropriate. Whatever's being recommended, apply both ways. But unfortunately, this report, and I'm not faulting Miss Height, because I viewed these relationship escapades, as I would call them, as certainly not within my realm of understanding, but there are people out there that do those kinds of things. And, if it's between the two of them, that's fine. But I think it had a real impact and really portrayed Mr. Torres in a bad light. And again, without that connection between that stuff and his care for the child, I just think it's premature to consider such a major change to the current parenting plan. Thank you.
Thank you. Mr. Pelley, do you have any input just regarding, there was some indication that there had been, I think, 25, 27 driving infractions issued to Mr. Torres. Do you have any comments related to that?
Well, I'll tell you, he is not going to be on the Allstate Good Driver commercial anytime soon. So yes, there is a history of that. But again, those issues were all raised in front of Judge Hahn, and Judge Hahn stated specifically in the May 21st order that as long as he's got a valid license and proof of insurance, he's free to transport the child. And I'll be serious, Your Honor, he understands he's under the microscope. And he understands that if he engages in that type of activity with the child, then, life is going to get a lot more difficult. So, he seems like an intelligent person, holds a good job. I don't think he's going to do anything to risk the ability to transport the child, because, he's sort of on an island here. Fortunately, Miss Partain came up from Texas. She's an old family friend. She's been there to assist in this, but if she's gone, he wouldn't have anybody as a third party able to transport the child according to the terms of the GAL, meaning that the child should know that person, be acquainted with that person. So I think he understands that life would be significantly more difficult if he fails to mind his P's and Q's on the road.
Thank you, Mr. Foley. Ms. Powers?
Thank you, Your Honor. First, I wanted to start out by letting the court know, the court did on May 21st look at the driving issue. We had asked the court at that point to prohibit Mr. Torres from driving with the child, and the court denied that request on May 21st. The court did not have the interim GAL report in front of them that day. I had not added a docket notice to ask the court to review that at the same time as the other hearing and contempt. So the court was not considering the GAL report at that point. There's been a lot said about the sexual relationship between the parties, and I think what is being overlooked from Mr. Torres's perspective is that this was not a consensual situation, and based on the information in the GAL report and the information according to what my client has provided, this was a sexual relationship that impacted both day and night. There is no way that this relationship could not have had an impact on the children, because Miss Wolski had to take photos of herself on demand. We have here a situation where there's been this power and control dynamic throughout the relationship, and that's continued to play out after the parties have separated. The GAL report brings forth really significant concerns about Mr. Torres's lack of self-awareness, lack of self-control, and the way that he flies off the handle and reacts not only in his sexual behavior, but also in his driving behavior. And this child is a young toddler and does not have the ability to protect herself or stand up for herself when Mr. Torres is flying off the handle or reacting inappropriately. We think that the concerns are valid. We agree with the recommendations in the GAL report, specifically no overnight visits. And I would like to speak for a moment about the text messages. The parties did have some text messages ahead of this hearing where Mr. Torres initially agreed to follow the GAL recommendation to stop overnight visits. And my client was on board with that until Mr. Torres followed up requesting more visits than what were just recommended by the GAL. My client is in a position where she has been a victim to Mr. Torres on a regular basis, and they do not have equal power to negotiate. And so Ms. Wolski became concerned that this was another attempt for him to manipulate the situation and make her look like the bad guy. As a result, she did speak with the GAL, and she decided at this point it was wisest to just follow the court orders instead of trying to work with Mr. Torres. This does not mean she wasn't concerned about overnight visits. She was, but she felt it was more important to keep the power in the court's hands, since this wasn't just going to be a straightforward agree and do what the GAL recommended. So at this point, we do ask the court to go ahead and adopt the GAL recommendations. I understand if the court feels that the driving issue has already been decided, but regardless, we do ask that the court adopt the GAL recommendations.
Thank you.
Your Honor, I don't know if you want to hear from the GAL before me or.
You opened your mouth, I'll hear from you.
Okay, thanks. Your Honor, and I'll just for point of clarification, when counsel indicates that my client was asking for more time than what was available under the GAL report, what he was saying was, right now, under the order, I have the weekend visits. And so what he would like to do, what he proposed to do, was do a Saturday visit and a Sunday day visit, Saturday day and a Sunday day. And what the guardian ad litem is proposing is limiting that to 1 day visit, the first, third, and fifth weekends of every month. So I don't view that as a substantial breach of the balance of power and bullying. Again, when I listen to counsel's argument, I don't disagree with her characterization of the parties' arrangement. I would argue, though, that certainly, despite Ms. Wolski's protestations, this was a consensual relationship. These same arguments were all made before Judge Warning, and Judge Warning was the one that issued the protection order in favor of Ms. Wolski. He did not include the child, and that was specifically because there was no nexus between all of the horrible, horrible things that Ms. Wolski says about Mr. Torres. There's no connection between that and how it impacts his ability to care for the child. I do have some concern about Ms. Wolski's ability to follow the order. There was a visitation scheduled this weekend. It didn't happen. Ms. Height was involved, I think, in the exchange of emails, and I think that's due in large part to Ms. Wolski's assumption that the court's going to grant this order. And that's a real concern. So I think until there's more information before the court regarding how Mr. Torres's proclivities affect his ability to care for the child, I still think it's premature. Thank you.
Thank you.
Your Honor, can I just very briefly reply to the last weekend?
Sure.
My understanding is that the visit did occur. It was an hour late. My client had gotten confused about which weekend it was. And when she realized her mistake, did provide the child. The exchange happened, but it happened a little bit late.
Thank you. Ms. Height, you unmuted.
Thank you, Your Honor. Yes, that when the first falls on a Saturday, which it does every once in a while, and the parties think that's the first weekend, I actually had 3 different cases call me disturbed about whether it was the first weekend or the 5th weekend, and so that it was confusing for all parties, and it was unfortunate that there was a misunderstanding, but the visit did occur. My concern, speaking of the nexus, is that there is a long history of compulsion and impulsivity that affect everybody in the household. So that would be my reply to that. Other than that, I have no other comment, Your Honor. Thank you.
All right. Thanks everyone for your input. I appreciate that. So we have a situation where we have a young child, and we have 2 parents who, during their time together, engaged in a sex life that is probably aberrational. If you look at percentage of Americans that engage in that type of behavior, it's probably a small percentage. So it's not unheard of, and it occurs. And so that's kind of front and center here. And then I think that the comments about the nexus are appropriate to talk about that, because you think about a relationship dynamic where a couple is together, they're trying to make it work. Oftentimes, just yesterday, I was in a criminal matter where an 87-year-old man was accused of hitting his 80-something-year-old wife in the back of the head at Rite Aid because she didn't get the right candy or something along those lines. And she was exceptionally defensive of her husband and thought this whole thing, and she used full language. She thought this proceeding was BS. And she said it didn't happen, nothing happened, and yet there was video of the episode. So we know that it did happen. So I highlight that to emphasize that in relationships, there's dynamics, there's patterns that evolve that are not necessarily healthy nor necessarily beneficial for the full development and well-being of each partner. So what is and I looked at this because I think, like I said before, the percentage of Americans that engage in that type of sexual relations is probably not, it's definitely not the majority. Would be my estimate. And so I tried to keep an open mind to all of that. And while doing that, I think that for me, that power dynamic and if nothing more than the mind control of where there's pictures on demand of private, intimate parts of another human being, and the concern that if that didn't happen, that there would be repercussions, frequency of demands of physical presence and of another. And so that it raises this issue of self-control. It raises this issue of postponing gratification. It raises this issue, and it ties in, I think, to potentially to driving, where if you don't get your way, because a lot of times when we're driving, people do frustrating things. They cut us off, and they don't signal. They endanger us. We feel frustrated by their actions. And when somebody's in a relationship that's not following what you want them to do, that those issues of control and exasperation might come into play. And the same, I think, applies to the driving concerns. Is that an individual who has there's these rules, the rules of the road that protect everybody, including the drivers and other drivers. And then when there's a general unwillingness to follow that, there's a sense that you're above and beyond the rules of the road that are there for the safety of all. So I think that nexus has been met in that the issue of the child. So here we have one parent that's exercising control, bodily and mind and emotional, over a fellow human being, their partner or spouse. Then you have a child who's really at a more significant disadvantage of ability to protect themselves. And then you can tie that into the driving, and there's kind of a power dynamic there also, that one party feels that they're above those particular rules, those particular laws. that are destined or aimed at protecting all parties, everybody on the road. So I think there's some concerns, at least at this point, that have yet to be explored and tamped down, if you will, about the safety of the child in respect or in connection with the father's ability to control himself and also to not exert unnecessary or overbearing control over another human being. So the request from the GAL for kind of a surprise or within 2-hour UA regarding alcohol for the father, I'll grant that. I think that's appropriate, and that if there's an issue, it can be addressed. If it's not an issue, then that issue may be dispelled by that. The driving, I recognize that another judicial officer had possibly heard that particular issue, but I think here we heard more information about the 26, 27 infractions over a period of time that caused me to rule that the father will not transport the child in a vehicle. And I think that's important because it shows a really strong, very strong pattern of disregard for laws that promote safety. And if there's a past pattern of inability to abide by common sense rules that promote safety, even though it may be inconvenient for the driver, when that's been disregarded so many times, I don't have a lot of faith and trust that there would be a continuation of or a change of behavior. So there'll be no transport of the child by the father. So as far as the parenting plan, I think it's warranted that there be a change here also. And again, you know, much of this may be dispelled through further investigation and evaluation, but at this point in time, there's some concern about co-sleeping. I think that's well-founded. And so there's not going to be any overnights for the father. So the mother will continue to be the primary custodial parent. And the father will have visitation on the 1st, 3rd, and 5th Saturdays from 10 a.m. to 6 p.m. and a Wednesday midweek from 5 to 8. And that Ms. Wolski will continue in her efforts with counseling. I tend to agree with Mr. Foley said that the PTSD is probably pre-existing, but I don't think that it was unexacerbated. In other words, it was probably exacerbated by Mr. Torres's conduct. So she'll continue in that. Mr. Torres will need to get a domestic violence evaluation and follow up with any treatment. Certainly collateral input from Ms. Wolski is appropriate. The SUD evaluation, substance use disorder evaluation for Mr. Wolski is warranted. And other than hearing from Mr. Foley indicate that it should go both ways, I don't remember in the pleadings if that was a specific issue that was addressed as far as Ms. Wolski's alcohol consumption. So since I don't recall that, it'll be in one direction, unidirectional, meaning the father will undertake that evaluation and any recommended treatment with collateral input from Ms. Wolski. The prohibition of no alcohol, no marijuana use 8 hours before residential time applies to Mr. Torres. The psychosexual evaluation and any recommended treatment is authorized and ordered with collateral input from Ms. Wolski. The exchange will occur at the Hall of Justice. The bathing issue, I think everybody's it sounds like everybody's okay with that, and that the father would not be bathing the child, that the roommate would be handling that and helping with that. And I think also this is important to note also that there's some indication of putting the child squarely in between the parents with coaching, quizzing, and questioning of the child. Please do not do that. Please do not force that position upon the child, and which will be highly detrimental to the child if that's continued. And also the parties are ordered not to disparage the other parent. And if you want to put that in an affirmative tone, speak positively of the other parent, because that does nothing but build the child up and restore their confidence. So I think those are the items that I wanted to address. I may have missed some that were important to each of you. If I did, please let me know.
Your Honor, I think the only issue was, I know Ms. Height had some deadlines in her report. What kind of deadlines is the court considering?
And you're referencing a final date or the final GAL report, correct?
No, actually, I'm number 5. there was some talk about it completing a 5-panel test by May 8th. And I realized that applies to, the SUD, all of that. Does the court have a preference as to when those things should be accomplished?
So I think that one was accomplished, was it not? He
Right.
took the 5-panel and it showed THC metabolite. As far as you're talking about the additional UA, kind of the surprise UA provision.
And then I'm assuming the court would just order a reasonable period of time as far as scheduling, like with Dr. Johnson, those kinds of things, because that is going to create some difficulty.
Yeah, any efforts to get those appointments scheduled soon and get that started promptly is definitely the court's expectation. As far as the UA, the reasonable time period, I think a 2-hour time period to make arrangements. If you're in the middle of a project or doing something at home or work, you get the notice, 2 hours, kind of wrap things up, make some adjustments, and I think 2 hours is a reasonable period.
And then just as far as sort of my client's road back to overnights, and transportation. I understand the evaluation from Vancouver guidance that's going to impact overnights. Can the court give my client some idea of what it would be looking for as far as getting back to the point where he could transport the child? I mean, he's dealt with all of his prior issues. There's no outstanding fines, no suspensions, things like that. So I know he's going to ask me, what do I have to do to get back to that point?
It's a good question. I don't know. The concern that the court expresses is a pattern of disregarding laws of safety, rules of safety. So whatever he feels that he can do to build or restore that confidence in his ability to and willingness to follow those rules would be manifested in some way that I'm not exactly sure.
Maybe a NHTSA class or some type of a driver safety. Would the court consider those? So at times when persons have engaged in behavior that's maybe aberrant or not following the rules. So education generally is well looked upon. If there's education, there's somebody, oftentimes when people learn something new, that'll change behavior. Okay, thank you.
Yeah. Ms. Powers?
The court wants to set a review in 30 to 60 days just to check in on the status of the evaluations. I know those can take a long period of time, but maybe it would be prudent to just kind of keep that tracking.
Yeah, Mr. Foley, any concerns if we were to set maybe a tracking date to just see progress on where those, if appointments have been set, at least, as a bare minimum, maybe within 30 days?
Yeah, no, I think that's good. And I think to have a little bit of leverage with Dr. Johnson would be a good thing. I'm not out to disparage him, we're friends, but I do know that he's known for the length of time it takes to get a report done. So to have some kind of leverage in the form of a review hearing, I think would be very helpful.
I would like a review just on July 16th at 9 a.m. if the parties are available to check status of all those evaluations, ensuring number one, that they've been made. And if not, why not? Because I think at that point of time, July 16th, appointments should have been made. And if some or not all of the evaluations, hopefully will be completed, with Dr. Johnson maybe being the exception. As far as preparation of today's order, Ms. Powers, would you be in a position to prepare that?
I can, yeah. Does the court want to set it on your presentation docket June 21st?
That presentation doc would be good. Let me check my calendar on the 21st because I think I'm absent. Yeah, I'll be in Seattle for a commission meeting. So we could look at the 28th would be one option. June.
That works. That would be fine for me.
Mr. Foley?
That's fine, Your Honor. I have 2 matters on the docket down here. So maybe if we could be moved to the end of the docket, that would be great.
So on that Friday docket, it's a pretty, I think there's only 3 cases that are allowed on for presentation docket. So
okay.
Expectation would be is 8:45 and hopefully done by 9.
Okay, that'll be fine.
Okay, Ms. Height, does that work okay for you?
Yes, Your Honor, thank you. And I believe it would probably be prudent for me. This was an odd orders appointing in that there was no date set for a final report. So it seems like without the information from all these evaluations, it's not going to be the best report we could come up with. So would it be prudent to just wait until we kind of get a possible date of Mr. Johnson, who'll probably be the final one, Dr. Johnson's evaluation, and then set a final date somewhere in a scope of time there.
Maybe what we could do when we come back on July 16th, we could reevaluate that. And Ms. Hyde, if you'd remind the court to address that particular issue in choosing
Right.
a potential date for a final report.
That makes a lot of sense. Thank you, Your Honor.
Right, thank you. Right, if there's, so we have that date set for presentation. Everybody's good with the 28th at 8:45? I think that's right.
Yes.
Okay, great. So we'll see everybody then. Thanks everybody for your input and help.
Thank you.
Thank you, Your Honor.
8, Ms. Bliss represents Ms. Vyers. And am I pronouncing that correctly?
It's pronounced Veers.
Veers, thank you. And so she's representing Ms. Veers. And then we have Mr. Samuel Anderson. I see that.
Good morning, Your Honor.
Good morning, Mr. Anderson. All right, let me just pull up my notes and get ready. This is Ms. Veers' motion to modify, or motion to, for adequate cause to modify a parenting plan. So I've reviewed the pleadings of the parties that submitted. So I'm ready to hear arguments. So I'll hear from Ms. Bliss and then from Mr. Anderson, please.
Thank you, Your Honor. And for the record, Carly Bliss on behalf of the petitioner and moving party, namely Shelby Veers. We are before the court today with a request for a finding of adequate cause and a request to modify the parenting plan. As the court is aware, a final parenting plan was entered in this matter in December of 2019. The parties have largely been operating off of that parenting plan until March of this year. As Your Honor likely saw within our pleadings and within that final parenting plan, both of these parties have suffered with long-term alcohol usage and abusage. My client has remained sober for the last 7 years. Mr. Anderson, on the other hand, has not and has recently relapsed from my client's perspective. In March of this year, my client was receiving concerning messages from Mr. Anderson's family members concerning statements of the child, specifically indicating that she's observing her father drink while in his care, drinking and driving, drinking in the car while she's at the park, playing on the playground by herself, things of that nature. My client provides for the court that on the night in question, my client specifically asked Mr. Anderson to undergo a BAC or a UA. She provided to the court the proof of her payment and a statement from the provider indicating she did pay for after hours testing. Mr. Anderson failed to comply with that testing. As outlined in the parenting plan, neither party is to consume alcohol while the child is in their care, and both parties are afforded the right to request testing in the event that they assume or suspect that the other party is using or under the influence of alcohol. My client provides for you that upon Mr. Anderson's failure to submit to testing, she came to the home to retrieve the child, as she did have significant concerns that he was not only drinking with the child in his care, but was drinking and driving. And she provides to you that earlier that evening, she crossed paths with Mr. Anderson driving on the road. She suspected that he was intoxicated given the GPS tracking of the child showing that they were not only at the park, which my client provides to you. The child has repeatedly said that while she plays at the park, daddy sits in the car and drinks. But not only that, the GPS also showed Mr. Anderson stopped not at a store, as he attempts to mislead the court, but at the liquor store. So my client did have significant concerns regarding Mr. Anderson's sobriety, came to the home, tells you he smelled of alcohol, he was clearly intoxicated, and at that point she attempted to remove the child from his care. He agreed to allow her to remove the child from his care. Since that time, the child has remained with my client 100% of the time. Mr. Anderson has come to or has been invited to various extracurricular activities. My client has offered supervised visitation while this matter is pending before the court. My client has significant concerns regarding this child's safety with Mr. Anderson. And this isn't the first time that this issue has been brought before the court or been addressed with Mr. Anderson. This was a lengthy litigation the first time around when these parties entered into the final parenting plan. Alcohol use has always been a concern of my client, which is why that provision was contained within the final parenting plan. The parties entered that final parenting plan by agreement. Because of that agreement, my client agreed to remove 3B findings for substance use, so long as that provision was contained in section 14, which is why it's in there. Pursuant to the final parenting plan, neither parent is permitted to drink. During the time with the child, Mr. Anderson admits to drinking while with the child. Obviously, this is not only a basis for contempt, but furthers my client's concern that alcohol use is absolutely an issue here. Any person who does not suffer from some sort of alcohol abuse can abstain from alcohol when required to for 36 hours, which is when he has the child. Clearly, that's not in Mr. Anderson's capability, at least at this point. So my client is asking for a substance use evaluation. Mr. Anderson provides dated substance use evaluation that he took in 2018. If you look at that evaluation, it does not reference any sort of collateral contact from my client. It simply states client reports that he doesn't drink or doesn't have urges to drink. A friend of his indicates he's never had an issue with drinking. And my client provides they've always had an issue with substance use or alcohol use, excuse me. And that is the crux of the concern within the parenting plan, and it always has been. Not only is this a dated substance use evaluation entered prior to the final parenting plan being entered, but did not include any sort of collateral contact from my client, which is typical. So we are asking for a new substance use evaluation. We are asking for collateral input from my client to avoid this same self-reporting, which oftentimes results in no treatment being recommended. Clearly, there's some concerns here, and obviously those need to be addressed. Sienna is 11 years old. She just had a birthday. She's still of a young age, and she still needs some protection. My client's asking for her temporary parenting plan to be entered, at least at this point, pending some sort of evaluation and recommended treatment for Mr. Anderson, which allows him supervised contact with the child. My client has historically and will continue to do so, allow him to come to extracurricular activities, community events, things of that nature where the child is participating. But at this point, it's clear that his alcohol consumption, even when prohibited by the court, is still occurring when the child is in his care. The most recent concern of him drinking and driving with the child in his care is very concerning. So we are asking the court to enter our parenting plan today, order Mr. Anderson, to complete that substance use evaluation. We are also asking for reimbursement of the $285 that my client paid for that testing. She provides the receipt to the court. She was not refunded those funds. She did pay $285 for after hours testing. Mr. Anderson acknowledges that he refused to comply with the testing. So it's only fair at this point that given his refusal to test, he reimbursed my client those funds. We are also asking for a contribution to fees and costs. My client did have to bring this motion and petition before the court today, given Mr. Anderson's actions. So we are asking for a contribution to attorney's fees.
Thank you, Ms. Bliss. Here, please, from Mr. Anderson.
Good morning, Your Honor.
Good morning.
Where to start? So much. So I've already went and scheduled a evaluation for the 25th of this month to get started on that.
Where do you have that scheduled at?
The Family Health Center.
Okay, thanks.
I just feel like she's been withholding visitation against the current order for the last 3 months. I agree to pay the test fee, but not the attorney fees.
Okay.
She's requesting.
What other input do you have? I read your declaration where you talked about the drinking during the residential time, the not taking the alcohol test because you admitted, yeah, I was drinking, and then you talked about the withholding, and then you mentioned that Ms. Veers had struggled previously with alcoholism and willing to do the SUD evaluation. And what else do you want to share?
I asked the court to please have the existing visitation schedule and parenting plan remain in place at this time due to our daughter is a known immediate danger or harm and the claims made by Ms. Veers being exaggerated or false. The last 3 months, Ms. Veers has caused an abrupt and drastic disruption in the regular and frequent visitation and time my daughter and I have spent together, and I am concerned about the strain on the relationship if she be allowed to continue to withhold my visitation.
Thank you, Mr. Anderson. All right, Ms. Bliss, any reply?
Nothing at this time, Your Honor. I think my initial argument and my client's pleadings stand for themselves.
Okay, all right, thank you. So going back to the parenting plan that was issued back in December of 2019, I wanted to just revisit that to make sure I'm understanding that correctly. Let's see, let me just pull it up. So in that parenting plan, I was looking at, there's a provision that alcohol testing, either party can request that. And then Ms. Bliss, maybe you could point out to me, probably faster than I could probably locate it, the paragraph that restricts alcohol consumption during residential time.
It's that same paragraph. So it's section 14, subsection K, the very first line, neither party shall consume alcohol or illegal substances 24 hours prior to or during visitation with a child.
Thank you.
Mm.
All right, appreciate that. All right, so we have the episode that occurred back in March, where there's fathers with the child, and there's concern that he's drinking, and he confirms that he had been drinking. Ms. Veers paid for the test, and he declined to take that, indicating that he drank. And so there does need to be the reimbursement of that $285. So that'll need to be done within 30 days of today. So you can generally, a good way to do that is just make payment directly to Ms. Bliss, and then Ms. Bliss can get that to her client, and that'll be recorded through a third party. So, I think when I look at this case, a party who's had issues with alcoholism in the past, likely, not always, likely will have maybe less tolerance for somebody who continues to drink, because there's a concern that if you take one drink, then you're going to take 4 drinks, or the slippery slope. That somebody who's been down that path before and is remaining sober or in recovery just doesn't have a lot of tolerance for that. And I think that's maybe what's motivated what is the 3-month withholding. I appreciate that Ms. Bliss indicated that there were some efforts to include Mr. Anderson, the father, in visitation, family time, or activities. But 3-month withholding, I looked at that askance, and recognizing that there may be some strong feelings and rationale behind that. So that was softened somewhat by Ms. Bliss, indicating that there had been contact with the father and the child.
Your Honor, may I speak for a moment?
No, Shelby.
No, you may not.
Okay.
You've spoken loudly with your actions. So I recognize that that withholding was likely motivated by a protective concern for the child and the safety of the child. I recognize that. I recognize also that 3 months, that's excessive. Nonetheless, I'm going to grant the motion for adequate cause. I think there's when there's a provision in a parenting plan that explicitly states do not do X and X is done, that's of concern to the court, and I think that's a significant change in that not only Mr. Anderson's circumstances but the child. So I'll grant the motion for adequate cause. As far as the parenting plan, the SUD evaluation that's set for June 25th. I'm glad that you've got that set up, Mr. Anderson, and that Ms. Veers will have collateral input regarding that evaluation. And then if there's any treatment recommended, then Mr. Anderson, you'll need to sign what are called ROIs, releases of information. So there can be monthly updates to Ms. Veers as to your status with treatment if it is recommended. The prohibition of consuming alcohol during any residential time remains, and it's specifically there's an indication that it's a 24 hours prior to visitation, and also during that prohibition continues to be there. It just can't happen. Just can't drink before having the child and during the time with the child. Just cannot happen. So as far as alcohol testing during Mr. Anderson's residential time, I'll grant that to allow Ms. Veers to request testing. She'll do a prepay. And that testing has to be accomplished within 2 hours of the notice being given to Mr. Anderson. If it's positive during that residential time, then all visitation is suspended pending visitation or pending coming back to court and the court ruling on that issue. If that Mr. Anderson there's no indication of alcohol in that testing, then Ms. Veers would eat that cost, if you will. She'd pay for that. If it's positive, then Mr. Anderson would be required to pay those monies back to Ms. Veers. So until the SUD evaluation is completed, there's going to be supervised visitation by a third party. It doesn't need to be a professional. It just needs to be a third party. And that will occur on Thursdays, every Thursday from 4 to 7 p.m. and every Saturday from, I listed 4 to 7, but that seems short, at least on a Saturday. So I'm going to change that for a longer period of time, from noon until 7 on Saturday. Video visits will happen Monday, Tuesday, Wednesday, and Sunday at 5 p.m. Doesn't have to happen it doesn't have to be a long drawn out conversation, just kind of touch base. Hello, how are you? And that'll need to happen on Monday, Tuesday, Wednesday, and Sunday at 5 p.m. So once the SUD evaluation has been completed and treatment has started, then we'll need to come back to look at the next steps for the parenting plan. So if the SUD evaluation is completed and no treatment is recommended, then it would be back to that regular parenting plan of December of 2019. If the evaluation comes back and it's recommending treatment, that I do want to have a hearing prior to making any changes to this temporary pre-evaluation parenting plan time. So those are the court's rulings. I'm happy to entertain any questions if I had missed anything or overlooked or clarification.
Your Honor, who's the third party for the supervision?
Do you have a proposal of who could be that person?
I have a neutral party that can be.
And who's that?
Kathy Holding. She's been our in-between neutral
Okay.
party this whole time, family member.
Okay, Kathy Holden. Ms. Bliss?
I'm aware of Ms. Holden. She has been the party's kind of intermediary throughout the lifetime of this case. I don't imagine that my client would have too strong of an objection. I know in her proposal, she proposed that she be the supervisor. I understand that's a little uncomfortable, and with tensions currently, that may not be appropriate. But I would just make that pitch to the court as well.
Okay, I'll approve Ms. Holden as the supervisor. Any other questions?
You said Monday, Tuesday, Wednesday, Sunday for those video visits?
Monday, Tuesday, Wednesday, Sunday.
Okay.
Yep.
And transportation for visits?
Let's see, in the parenting plan of 2019 December, is that included therein? I would assume it would be.
Yes, at that time, the picking up parent was providing the transportation. I know my client would just recommend or request at this point that she provide the transportation, just given the driving and drinking concerns, at least pending the SUD treatment recommendations.
Okay. Mr. Anderson, do you have an input on that?
I disagree.
Okay. So pending the evaluation being completed, I'll have Ms. Veers be in charge of the transportation once the evaluation has been completed. If there's no recommendation provided for treatment, then Mr. Anderson can do the transport. If treatment is recommended, I want to come back and address that issue before we change Ms. Veers being in charge of transport. But we could certainly, once we have the evaluation, we can look at that with fresh eyes. Any other questions?
Yeah, can you just repeat the weekdays for visitation?
Thursday, 4 to 7 p.m. and Saturday, noon to 7 p.m.
Thank you, Your Honor.
Okay. As far as a presentation date, Ms. Bliss, do you have a time frame that would be helpful for you and your client and Mr. Anderson getting that out?
I imagine your Friday docket would probably be easiest for me.
Yeah, that's what I'm looking for, a Friday morning at 8:45.
Do you have a docket on the 28th?
I do.
Can we plug us in there?
That would work for my schedule. Mr. Anderson, June 28th at 8:45 in the morning for presentation. Ms. Bliss would be preparing an order reflecting the court's order today, send that to you. And if you agree with it, you can certainly sign off on it as being reflective of what the court ordered. If you feel that it's wrong or there needs to be an adjustment, then we'd have that hearing on 8:45 on June 28th, Friday.
Is 3 days enough time to get the final evaluation?
You said is 3 days enough because you've got the June 25 SUD evaluation, correct?
Yeah.
Yeah, it's probably, you know, what the order is going to say. The order is going to reflect what the court ordered here today. So the fact that the evaluation is 3 days before doesn't necessarily wouldn't impact the presentation of that order on the 28th. So it looks like you're still muted.
Thank you, Your Honor. Sorry.
Okay, so you would be available then June 28th, 8:45 for the presentation docket if you don't sign off on it?
Yes, Your Honor.
Okay, we'll set it for that date. Anything else, Ms. Bliss or Mr. Anderson?
I would just ask Mr. Anderson, when you do complete that evaluation, that you provide them my email address so they can send me a copy of that evaluation upon its completion.
Yeah, that would be appropriate. All right, very good. All right, we'll see everybody on June 28th. Thank you.
Thank you, Judge.
Thank you.
Cause number. Ms. Gilmore is present. She represents Kevin Cahill. And Ms. Jackson, I think you're representing yourself, correct?
Yes, sir.
Okay, and she's present. And then Ms. Jocelyn is here representing Elizabeth. And Ms. Jocelyn, are you here?
Yes, Your Honor, I'm here.
Oh, very good. Great. Let me just pull up my notes and then we'll go ahead and get started. All right, this is Mr. Cahill's motion related to a modification of decision-making as it relates to extracurricular, and also just decision-making in general. So I read the input that each party submitted and filed with court. So I'm ready to hear from Ms. Gilmore, and then we'll hear from Ms. Cahill and then Ms. Jocelyn.
Yes, Your Honor. Thank you, Megan Gilmore, for the record on behalf of petitioner Kevin Cahill. This matter is before the court on my client's motion to address decision-making relating to extracurriculars over this summer, as well as broader picture of extracurriculars and decision-making in general. Looking to my motion, there was some correspondence back and forth between the parties in March of this year regarding extracurriculars and my client asking if she would authorize the child to be in rodeo. She indicated back in her response to my client that she needed more information. I subsequently drafted the correspondence attached to our motion from April, outlining the activities for the summer, and we projected what was going to be potentially a conflict for her weekends and asked her to provide the child to those events, or alternatively, we were willing to, or my client was willing to take the child to the event and discuss makeup time. We didn't receive a response, and that's what necessitated this motion. Now, mother indicates within her responsive pleadings that she doesn't agree for a variety of reasons. My client isn't looking to interfere with mother's time, and my client was frankly more than willing, as indicated within our correspondence as well as the email correspondence, to frankly do whatever was in the best interest of the child and work with mother to ensure that the child could participate in the events, but again, still have visitation with mother. There was some sort of conversation or discussion or argument in her declaration that we were asking for her to forfeit all of her summer visitation. Again, looking back to that correspondence, I do believe that only 2 weekends conflict with her visitation. Again, we simply ask that she participate in the events, support the child. But again, if she's not willing to do so, then my client would be able to take the child to the event, and we could discuss makeup time if that is warranted by the court. My client denies the allegations of behavioral issues by the child. He frankly obviously isn't aware, doesn't have personal knowledge of what happens at his home, or excuse me, mother's home. But I would look to the email correspondence. She's not referencing these alleged behavioral issues within the email correspondence. She mainly is citing, frankly, she just doesn't want to take the child to the events and wants to pressure my client to modify the summer schedule, which at this point he wasn't willing to do. My client explains that he's worked closely with the child provider since we were last before the court. The child has subsequently completed probation, has graduated from the WISE program, and has completed the outpatient mental health with Columbia Wellness. My client, as again indicated within the communication submitted by respondent, my client simply asked that the parties set aside their differences for the best interest of the child, and again asked to just simply work this out because again, it's in the best interest of this child to participate in extracurriculars. My client explains that this child has been preparing for these events throughout the year, training for this, and I think just in general, extracurriculars are good. They create stability, accountability, for the child, and frankly, a schedule in the summer that he will be responsible for complying with. We do ask the court allow the child to participate in these events, again, as it is in his best interest, and my client is more than willing to have facilitate any change to the schedule or provide, step in and provide the child the resources to get to the events during mother's time. We also are asking the courts to make a modification to the temporary parenting plan that was entered in January of 2023. We are asking the court to allow my client to have sole decision-making regarding meal. My client explains, and I think that frankly, it's borne out within the communications that are submitted by respondent. These parties frankly have no ability to co-parent, unfortunately. This case has been litigated heavily since 2011. This petition to modify was filed in 2016. Despite my client's best efforts to simply communicate, to coordinate visitation, ensure compliance with the parenting plan, there's simply no movement here. Unfortunately, to ensure compliance, I think that we're going to have to be before the court regarding any decision that needs to be made for the child, if it be football, if it be rodeo, if it be educational decisions, because again, what we see here is my client asking and providing the information. Mother indicates she needs more information. And again, my client citing the fact that we've provided the attachment with the information and we simply just received no movement here. My client is trying to avoid a contempt motion. He's trying to comply with the court's orders and he's trying to do what's in the best interest of the child. So we are asking the court to grant our motion, allow the child to participate in rodeo over the summer and to modify the parenting plan relating to meal and provide my client sole decision-making just to ensure, at least for extracurriculars, that this child can participate in these activities and not be put in the middle of these people's fighting.
Thank you, Ms. Gilmore. Ms. Jackson.
Sorry, Your Honor. This motion doesn't relate to my client. I haven't heard anything today that would warrant any input, nor has my client given me any information that would be helpful to the court.
Very good. Thank you, Ms. Jocelyn. Appreciate that. Okay, Ms. Jackson, I'll hear from you, please.
Yeah, I actually have a couple of concerns with what's being presented currently to the court. When we initially had a conversation about spring break is when I initially brought up the summer schedule and what was going on. I do have a stepson who has a parent outside of our household. And so we have to co-parent with that parent as well. I asked at that time back in March what the summer schedule was going to look like. I explained to Mr. Cahill specifically how time off works for my company. And if I wanted to request time off for June, I had to do it a month and a half in advance by the 15th of the month. I explained that. I've explained it multiple times to him as well as his attorney. I can't just change my schedule on a whim because they feel like I should, because they planned an activity for Neil. I understand that Neil wants to participate in these things. I'm not discouraging him from participating in these things. However, I do have to be given reasonable time to make reasonable accommodations. Him sending me emails or having his attorney send me emails a week or two before an event is not a reasonable time. My company that I work for requires a month and a half notice for time. The last time we agreed to make a change over spring break, Mr. Cahill failed to even bring Neil to the agreed change in visitation. So I just missed out on that time with Neil. I should have filed a contempt of court at that time, but I let it go because it was something that Neil wanted to do. So I don't understand at what point I can express that I don't have an issue with him participating as long as I am provided appropriate time to make arrangements. I also would like the other issues addressed, such as his multiple school suspensions, the actions he is taking. They can't say that you're
talking about school suspension.
So I do feel like I had brought those things up to him. I had asked what his plan for summer vacation was. If he give me dates, he was unable to provide them. I am a manager in a retail location, so I can't not work every weekend because that's what's convenient. I do try to not work on the weekends when the kids are with us at our home. But it does, like this weekend, I'm scheduled to work on Sunday. It's a holiday. All the fathers in our store are off. So it unfortunately is a weekend where I have the kids and I will have to work part of the day on Sunday. If I want a scheduling accommodation, I do have to give my company reasonable time to make that scheduling accommodation. I was simply asking for those dates back in March. If he could not provide them, I was asking for an alternative. He never even bothered to respond to any of that, and then brings a motion to the court saying that I never responded. I wasn't properly served by his attorney's office. They continued to serve me via email, even though I've asked to not be served via email. I've asked them, they specifically asked when they came on board with him what the best mailing address was for me. I provided that information to them. I do not get mail at our physical address. This was an issue last year with child support. It continues to be an issue as they continue to mail things to my physical address and not my P.O. box, even though they're fully aware I don't receive mail at our home address. And so saying that I just failed to respond is not true, because one, I wasn't aware of the request, and two, I wasn't allowed proper time to even make the changes. So I don't feel like it's appropriate for Neil to participate in the activities because none of the other issues have been addressed. And I don't feel like I should have to forfeit my time and plans that we have already made for the summer because they failed to communicate in a timely manner.
Can I ask you a question about the address issue? Have you filed a formal change of address notice?
I wasn't aware that the court ever had a different address for me other than my P.O. box. It is the one that I've always used. So no, I guess I have not, because I wasn't aware that they had a different address for me, sir.
Yeah, just to clear up any confusion in the future, if you could just please file that change of address form, and then that'll be officially in the records, and that'll kind of clear up confusion going forward. Appreciate that.
Yes, sir.
Just want to ask you about the school suspensions. You said there were multiple. What were the timeframes of those?
So there was one in December, one I believe in January, and then another about a month later. The first two were physical altercations with another student. And then the third one was a inappropriate contact with a female student in his shop class. And I do feel like both of those are reasons that he should probably be in counseling.
Do you think those are, I think in your pleadings, you alluded to the fact that that would be, because of those suspensions, that would be a reason for not allowing him to do rodeo, because that would be kind of something that he likes, and that would be a counterbalance to that behavior?
I kind of am not a fan of supporting bad behavior, and I do feel like when he's continuing to have these actions and continuing to do things that are not in alignment with normal school standards and multiple suspensions, like, why are we continuing to reward bad behavior? It clearly, trying to engage him in those things is not changing that behavior. So why are we continuing to reward it? And I do feel like it is a reward to him. He gets to go and not have to be at our house and be held accountable for those things. And so it is a reward to him.
All right, thank you. Okay, Ms. McClellan?
Yeah, just briefly, Your Honor. Again, my client provided notice as soon as it was available, the schedule. The schedule was available in April. We provided it in April. I am confused why she didn't receive the correspondence asking for an agreement to be reached, as I did provide that correspondence to her via her PO box that she's previously requested. I do apologize that my office has no intention of not serving her properly, but again, I think that my staff were relying on the notice of withdrawal that was from 2018, and we have received and provided service continued by email. So I do apologize if she didn't receive anything, but I don't understand why she wouldn't receive the communication from April 25th that was provided by PO box. As you can see from the argument, we simply are just asking for a firm understanding of what her position was. It seemed at the beginning of her argument that she was going to agree, but she simply wanted to come to an agreement about modification of the parenting plan. Now she's going back to the behavioral issues. I would object to the consideration of the alleged suspensions. I don't believe that was specifically outlined in her declaration, and my client could have provided a response. All I'm aware is that at least one suspension occurred based on the communications that happened in March. My client explained what he was doing with the providers and what was going on with the suspension. Based on my understanding, thereafter, the child has subsequently completed mental health treatment and completed some of these other programs to remedy some of the behavioral issues that were happening in the winter. So we are asking the court to provide this child the ability to participate in the events, and we are simply asking that my client, as the primary parent of the child who is engaged in all these services, be allowed to make decision making. I don't see from here that mother has she expresses concerns because she doesn't want to take the child to the rodeo, but I don't see her doing any legwork to be communicating with these providers despite her concerns. I mean, she obviously is an equal parent that needs to be making decisions, but I don't see that she's been doing that based on her alleged concerns. Also, as we're before the court, she has provided the court that she does have problems with her work schedule, but I haven't seen affirmatively that she's unavailable or has something planned for the weekends in question, which are only two. One's in July, one's August. I would also talk about the notice provided. We provided notice in April and the events in July. So I do believe that that corresponds with the work schedule notice. So I simply think that we just have an individual that doesn't want to take the child to rodeo. I don't think it's a behavioral issue. I don't think it's a conflict issue. And again, my client just simply wants to do what's in the best interest of the child.
Okay, thank you. Ms. Jocelyn, do you have any issues for you, Ms. Jocelyn? No? Okay. Ms. Jackson, you had a question?
Yeah, I just wanted to say that I do believe that I did reference the suspensions. I actually submitted several emails back and forth between Mr. Cahill and I where we talked about the school suspension. So I actually do feel like that information was provided to the court before today. And then I also, there's one other thing that she had said that I'm sorry, I forgot about it now. She says that she says that they provided information to me by April. I have to have my request in by April 15th. So even if she did provide that information to me on April 17th, which is my understanding of, it was either the 17th or the 20th when that email or correspondence was sent to me, it still was after the date that my company requires for any June dates that could be requested off. I did not receive any of that correspondence until Elizabeth told me we were going to court, at which point I went in search of it in my email and found it in a spam folder. So I have only had knowledge of this court hearing and those dates for about 2 weeks now. So still have not been able, I've submitted for the August date off, but I don't have any way to change my June schedule as of right now. And so it's not me not wanting to participate, it's me needing appropriate communication and appropriate time to request that time off. I feel like I'm being punished and having my rights taken away because I have a job that I must go to or request time off in an appropriate manner. And I don't feel like that's a reason to have my decision making taken away. I just need appropriate communication so that I can make the appropriate arrangements.
Okay, thank you.
Your Honor, can I clarify something for the court?
Yeah, go ahead.
I know Ms. Jackson indicated Lizzie told her about the hearing. I just wanted to clarify for the court, the only thing that was communicated to my client was there was a hearing and it was not concerning her, so we would not be discussing it and I wouldn't be disseminating any information to her.
Great. Okay. Thank you, Ms. Jocelyn. Appreciate that. Okay, the motion here is brought by Mr. Cahill to allow Neil to participate in the rodeo events over the summer. Ms. Jackson is concerned about notice and about the difficulties with scheduling time off with her work, that lead time of about 6 weeks and the like. So there's concerns raised about the addresses. I think that's going to be rectified just with that change of address being filed by Ms. Jackson, pardon me. So as far as the rodeo on July 13th and through the 14th and August 24th through the 25th, those are the 2 days that have been identified as conflicting or being on the residential time of Ms. Jackson. I'm going to allow Neil to participate in the rodeo on both of those dates. If Ms. Jackson can take Neil to the rodeo on those dates, then that would be her residential time with Neil over those weekends. If she's not available or if she's unable to do so or doesn't want to, then Mr. Cahill will be responsible and will have that time with Neil over those 2 weekends. I am granting Ms. Jackson makeup time in the fall of 2024. For those, if one or both of those weekends is that she's not able to use or spend that with Neil, then that makeup time would be in the fall of 2024. So the idea with the in-school suspensions sounds like Neil's worked through a lot of stuff. He's completed his probation, was on WISE, and he's completed his outpatient. So hopefully there's some lessons have been learned there, and that he'll be making some improvements. Oftentimes for young adults, having consequences happen close in time to the behavior that needs to be corrected is really important. When it becomes too attenuated or far away, such as exacting maybe some discipline for behaviors in December, January, February, happening in June or July or August, is a bit attenuated and may not meet the purpose that was hoped for. So I'll just make that comment. So I'm going to allow that the rodeo, Neil to participate in the rodeo this summer on those 2 particular weekends. As far as sole decision-making regarding extracurriculars going forward, the parties have had difficulty. You can feel the strain when reading the declarations between the two of them. It's palpable, and there's difficulty there. And yet I think there's not enough to make that change at this point. So I'm going to hold off on that. The parties will continue to work through some issues, and hopefully they can work through those. But decision-making and extracurriculars remains unchanged. So any questions on the court's ruling?
No, I don't.
I actually do. I'm not sure the court is aware of this, but Neil's suspensions actually came a year after he finished counseling. So he was removed from counseling in January of 23.
What's your question?
I'm not sure that the court is aware of that. I just was asking if you're aware that, I know you said in correspondence with.
Nope,
okay.
Not aware of that. Any other questions? Okay. As far as a presentation date memorializing today's ruling, we could look at a presentation of June 21, or I think June 21 or June 28th. Oh, I'm going to be on the 21st, yeah. June 28th, how does that look for the parties? Thank you.
That works.
Okay.
Your Honor, can I be excused from that hearing?
Yes.
Thank you.
Yes. And then Ms. Jackson, June 28th, 8:45 in the morning for presentation.
Yes, I am just trying to confer with my work schedule, sir. Just one moment.
Okay. So Ms. Gilmore will be preparing that order. If you agree that she captured what the court ordered here today correctly, you could simply sign off on it and we wouldn't need the hearing on the 28th. If you feel that she doesn't have it correct, then be here on the 28th at 8:45.
Yes, sir.
Okay, great. We'll set it for that date, Ms. Gilmore.
Just briefly, should I have a signature line for Ms. Jocelyn? I know that it's a little strange procedurally.
Repeat that question. I missed the first part.
Should I have a signature line for Ms. Jocelyn?
Ms. Jocelyn, what do you think?
I don't think it's necessary on this one because it doesn't relate whatsoever. So the disagreement's really going to come from Ms. Jackson.
Yeah.
Understood. And then also I would like to, Ms. Jackson, I will, hopefully we can coordinate those fall dates so there's just no conflict. I can put generic language that makeup time will be in the fall, but if we can try to coordinate those dates, hopefully we can do that prior to the presentation.
All right, thank you.
Okay, thank you.
Great. I appreciate that. Thank you, Ms. Gilmore. Thank you, Ms. Jackson. Thank you, Ms. Jocelyn. All right.
Thank you, Your Honor.
Conclude that hearing, and I believe that concludes the docket. If there's any other parties that are on the line today that are expecting their case to be called but has not been called, please speak up and we can address that now. Hearing none, that'll conclude the docket this morning. I'll go ahead and end the Zoom call.